Good evening. Wadham College and your warden do me a great honour by inviting me here this evening. I'm proud and pleased to have strong links to this college, and they include my friend and colleague Laura Hoiano here tonight, who most of you know, who is a full practising member of my chambers in London, Red Lion Chambers, and we're very lucky to have her. Laura follows in our recent tradition of having at least one academic member, either as a door tenant or a full tenant. Laura, in fact, followed in the footsteps of David Ormerod, now a law commissioner, of course, and we were delighted when Laura announced her intention to move up from academic door tenant to a full tenancy in chambers. This means that we are now looking for one or more new academic door tenants, so perhaps I've come to the right place this evening. I realise, however, that there is stiff competition based upon the fact that the warden is a distinguished member or associate member of another set of chambers in London, whom I won't name because you won't have heard of them. But in fact, as he said, Ken and I have known each other for a long time. It's at least 15 years and therefore at least half of my career at the bar to date. Before his appointment as Director of Public Prosecutions, Ken in fact was elected to serve as Chairman of the Criminal Bar Association in 2003, a position which he was only unable to fulfil due to his public appointment. And we were very sorry to see him go. And I say that with feeling because I was the Secretary of the CBA at the time, and I clearly remember a call from Ken whilst I was on holiday in which he told me the news of his appointment. And having been through a far more modest public appointment round myself recently, I can imagine Ken's relief when told that he had been selected to serve. The CBA managed to survive his absence, and to my astonishment I became chairman myself 8 years later. So your warden and I have some shared history, and not least because in fact we're currently both engaged in opposing roles in an ongoing prosecutorial investigation about which I can say no more, apart from the fact that it's a pleasure to see Ken over the conference table, which is where the idea for this lecture was hatched. All of which creates an embarrassing headache for me, though not for the warden, because I am a graduate of this university, but not this college. My own alma mater, St Peter's College, knows, I hope, that it has a permanent place in my heart, and I promise to visit again soon, if, maybe a big if, they can overlook this migration to Wadham this evening. Finally, for now, by way of introduction, I've been very pleased to meet Wadham students, undergraduate and graduate, on my previous visits here, thanks to Laura and to Ken, and to host one or two of you for visits to court in London to observe my cases. I'm looking forward to renewing acquaintances this evening, and if time allows, I'm sure that you have searching questions for me at the end of this lecture, either here and now, or perhaps more preferable, when I have a glass in my hand before, during, or even after dinner. A night in Oxford is always a treat, although my junior, whom I have abandoned halfway through a trial in Nottingham Crown Court this afternoon, may not agree. And so, to the subject of my remarks this evening, a challenging year. I was slightly alarmed actually on coming through the lodge to see the poster advertising this evening and the suggestion that this might be a rights-based analysis first and foremost. Whilst that will feature, my principal rights-based analysis over the 9 months in which I've been in post is actually to be found in the Tom Sargent Memorial Lecture which I gave to Justice 3 or 4 weeks ago. If you'd like to read that, it's on the Independent Reviewer's website. They're there for all to see. So, a challenging year. My predecessor, the excellent David Anderson, served 6 years as Independent Reviewer, 2011 until February this year. In that time, there was, of course, a great deal of activity and change in terrorism around the world, including, of course, the declaration of the so-called caliphate in Mosul in July 2014. In the UK, those years included the appalling terrorist murders of Fusilier Lee Rigby in Woolwich and Joe Cox MP in Batley. However, the police and security services here were so successful in disrupting attack planning that the years 2011 to 16 are remembered only for those two horrible cases. Thankfully, no other attacks of similar magnitude. By contrast, David's predecessor, Alex Carlisle, who's been mentioned, served with distinction for more than 9 years. I don't know how he did it. Having been appointed, I have it by recollection, it was the day before 9/11, but it was definitely the week of the attacks in the USA. As for me then, having taken over from David on the 1st of March this year, St. David's Day, appropriately enough, we all know the headlines from 2017 thus far. On the 23rd of March, 3 weeks after appointment, I wrote as follows on my independent reviewer website, quote, "The murderous actions of one individual on the streets of Westminster yesterday afternoon will be subjected to full scrutiny and investigation by our police and intelligence services. It is vital that we await the outcome before any detailed comment." Well, that event was followed, as we know now, by Manchester Arena, London Bridge Borough Market, Finsbury Park and Parsons Green. So that is a challenging year by any measure. And in the midst of it all, on the 4th of June, the day after the London Bridge Borough Market attack, there came the following announcement from the steps of 10 Downing Street by the Prime Minister. I'll just quote, if I may. "We have a robust counter-terrorism strategy that has proved successful over many years, but as the nature of the threat we face becomes more complex, more fragmented, more hidden, especially online, the strategy needs to keep up. So in light of what we are learning about the changing threat, we need to review Britain's counter-terrorism strategy to make sure the police and security services have all the powers they need." And then this was added, "And if we need to increase the length of custodial sentences for terrorism-related offences, even apparently less serious offences, that is what we will do." End quote. What to make of that? Well, whilst it should be clearly understood that counter-terrorism strategy, to use the Prime Minister's phrase, encompasses far more than the terrorism legislation which I review, it's inevitable that the Prime Minister had some form of review of parts of the legislation which I do review in mind. The outcome of the review will be one measure of how we have met the challenge thrown down by the events of this year. There has as yet been no announcement. My guess is that we will see an announcement, if not late this year, then early next year. I suspect that there will be a draft counter-terrorism bill containing whatever proposals the government thinks right in all the current circumstances. And my guess is that there will be proposals to clarify the meaning and reach of existing terrorism offences. But I doubt that there will be much in the way of entirely new proposed offences. We shall have to wait and see. So that's where we are currently. A reviewer, of course, reviews. He or she does not set policy, still less make laws, and there is a necessary delay between all of the operational activity after the terrorist atrocities that we witnessed on our streets this year and any attempt by me to sensibly review our legislation going forward. And of course, I do not have all the answers. I hope, however, to shine a light in perhaps some useful ways, and this evening I hope to provoke thought and indeed discussion later by touching on a number of topics, sometimes looking through the prism of what happened last year, as well as some reflections on what is happening this year. And may I add that my own first annual report as independent reviewer is with the Home Office as I speak for security and fact-checking, and I hope that it will be presented to Parliament before December is out. The title of it is A Report on the Operation of the Terrorism Legislation during 2016. What follows might possibly contain some hints as to the content of that report, but please note that what follows is merely my research, and any errors are mine. So may we then start with some statistics. During 2016, the overall threat picture for the UK remained at severe. Daesh continued to represent the most significant terrorist threat, but the UK faced a continuing threat of violence and terrorism from groups or individuals associated with the far right. And this was evidenced by the proscription of the extreme right-wing group National Action in December 2016, following the terrorism-related murder of Joe Cox MP in June of last year. There are 71 organisations proscribed under the Terrorism Act, and 14 organisations in Northern Ireland, actually under previous legislation. And there are 6 people, or were by the end of 2016, subject to TPIM notices, Terrorism Prevention Investigation Measure notices. Next, the Terrorism Act stop and search powers. They were used 483 times in Great Britain, with an arrest rate of 9%. Those powers were used 197 times in Northern Ireland. The power to stop and search without suspicion, however, was once again not used. The frequency of use of Schedule 7 powers to examine people at ports, airports, stations, ferry terminals, continued to decline. In fact, 17,501 examinations in Great Britain in the year ending June this year, June 2017, compared to 23,719 examinations in the previous 12 months, so to June 16. The number of Terrorism Act arrests across the UK decreased in 2016 compared to 2015, with Northern Ireland figures being the lowest recorded number of arrests in any year since 2001. The arrest power was once again used with far greater frequency in Northern Ireland than in Great Britain, but detention beyond 48 hours, which is common here, is still rare in Northern Ireland. That's the big difference. And there were 62 trials for terrorism-related offences in 2016. Of those, 54 persons were convicted and 8 were acquitted. And the concluded cases included those of Thomas Mayer, the killer of Joe Cox MP, and Anjem Chowdhury, often regarded as a leading hate preacher as well as leader of Al-Mahajirun. So those are some of the introductory statistics. Just a further word now about my role. The independent reviewer's role is to monitor UK counter-terrorism legislation, so that does include Scotland and Northern Ireland, not just the ordinary lawyers' jurisdiction of England and Wales, and to monitor it for its fairness, effectiveness and proportionality. The work is underpinned by 3 principles without which I suggest it could not function. The principles, identified first not by me but by my predecessor in one of his reports, are: first, complete independence from government; second, unrestricted access to classified documents and national security personnel; and third, a statutory obligation on government to lay the independent reviewers' reports before Parliament. So, to the legislation, let's look at the most recent changes to the mainframe of terrorism legislation as a means of assessing where we are now. Well, all four of the statutes which I now review, so that's the two Terrorism Acts, the Terrorist Asset Freezing Act and the TPIM Act, all four remain in force. There were no substantive recent changes, I'd suggest, but the following changes were made to the legislation during the course of the last year. Can I just list them? Schedule 8 of the Terrorism Act 2000 was amended by Section 71 of the Policing and Crime Act 2017 to enable DNA profiles and fingerprints to be retained indefinitely where a person has convictions outside the United Kingdom. And Section 68 of the same Act creates a new offence of breaching travel-related conditions of pre-charge bail. Statutory definition is travel restriction conditions, and that's of course for those arrested on suspicion of committing a terrorist offence. The Criminal Justice Act 1988 was amended by a Reviews of Sentencing Amendment Order, Statutory Instrument Secondary Legislation 2017, that added 19 either-way offences which trigger now the terrorism notification requirements which are contained in Part 4 of the Counter-Terrorism Act 2008. And there's a schedule to the original Review of Sentencing Order which dates back to 2006. So that has been added. Part 4 of the 2017 order, statutory instrument, allows the Attorney General, with leave from the Court of Appeal, to refer certain cases to the Court of Appeal where he considers that a sentence imposed in the Crown Court was unduly lenient. So an expansion of the unduly lenient sentence regime to cover much more of the terrorist offending, where previously that was not covered. There were also amendments to the 2000 Terrorism Act and Schedule 1 of ACTA, the Anti-Terrorism Crime and Security Act of 2001. The amendments were made this year by Part 2 of the Criminal Finances Act 2017, and that includes the introduction in Schedule 1 of the Act of a new power to administratively forfeit terrorist cash. That's in Part 2A. And there are new civil recovery powers to seize, detain and forfeit terrorist assets and terrorist money held in bank and building societies. That's Parts 4A and 4B. And finally, the prison amendment rules, amended by statutory instrument in 2017, which are linked to the special offences in the legislation, allow now for a special separation regime for extremist prisoners, as envisaged by the Aitchison report, Ian Aitchison report. And by Rule 46A of these amended prison rules, there will be separation centres within the prison estate with allocation of prisoners to those centres on any of the following grounds. 1, in the interest of national security. 2, to prevent the commission, preparation or instigation of acts of terrorism, a terrorism offence, or an offence with a terrorist connection, whether that offence, putative offence, is in prison or otherwise. 3, to prevent the dissemination of views or beliefs that might encourage or induce others to commit any such act or offence, whether in a prison or otherwise, or to protect or safeguard others from such views or beliefs. And then 4thly, to prevent any political, religious, racial or other views or beliefs being used to undermine good order and discipline in a prison. Interesting provisions. Maybe we'll talk more about that later. But pending the outcome of the government strategy review, that is where we stand. So, let's turn to one of the big issues of this year, which I'm calling foreign terrorist fighters. In the Home Secretary's words, in her published response to my predecessor's final annual report, And that response was published in July this year. You can find it. Home Secretary wrote this, quote, "UK-linked individuals who travel to fight in Syria and Iraq pose a clear threat to our country's security, and we continue to work at a national and international level to mitigate the risk they pose." Home Secretary continued, "For those who nonetheless still aspire to travel to the region and engage in terrorism-related activity, we have a range of tools to disrupt their travel and to manage their return. This includes using the royal prerogative to remove passport facilities, using temporary exclusion orders, TEOs, to manage their return, or when they're in the UK, imposing travel restrictions and other measures through the TPIM Act, imposition of TPIMs in other words. Anyone who returns from the region," the Home Secretary went on, "must also expect to be examined by the police to determine if they have committed criminal offences, and there have already been several successful prosecutions for those who have returned." The final two sentences are interesting. Home Secretary added, "Whether or not returners are prosecuted, we will take further action to understand and mitigate the risks they pose. This could include providing intense monitoring and psychological support through a de-radicalisation programme." End quote. So just pausing here for a moment. It is only right to acknowledge that I have received recent criticism for daring to suggest that not all who return from Syria or Iraq will end up facing prosecution in our criminal courts. When I pointed out this fact, being, I suggest, nothing more than what I've just read out from the Home Secretary herself, the Today programme interview in which I said it was immediately converted into front-page news by various publications of a certain political orientation, and the inevitable hostile backlash on social media raged to such an extent that I can assure anyone tempted to join the throng that I no longer read notifications on my Twitter accounts. But seriously though, of course we need a range of legal mechanisms to deal with those who return from conflict zones. Criminal prosecution, whilst inevitable for any and all who are found to have committed criminal offences whilst abroad, is not the only solution to a complex problem. We need flexible and creative solutions in this vital area. By and large, it remains my view that the legislative and, for the most part, the policy solutions are already in place, and the Home Secretary's words, which I quoted, confirm as much. So, new laws are only necessary as a last resort. Now, a word about threat levels. It's interesting, isn't it, to note that the UK threat level, set of course by JTAC, not by government, but by JTAC, the Joint Terrorism Analysis Centre, the UK threat level was elevated from severe to critical twice only this year to date. Namely, for a period of approximately 48 hours, very shortly after the Manchester Arena attack, and for a like period after the discovery of a partially detonated explosive device on a London Underground train at Parsons Green. The first was a reaction to the newly commenced investigation led by Greater Manchester Police, and the move upwards from severe to critical was justified because in the earliest days of that investigation it was unknown whether the perpetrator, Abedi, was a lone actor, to use the current phrase, or may have been part of a wider conspiracy. The level of sophistication to the Arena attack in Manchester, large improvised explosive device, assembled from parts which were gathered over time and stored ready for use, that justified an assessment which was absent, actually, after Westminster Bridge, Finsbury Park, or even London Bridge, the first two of which were lone actors, and the third London Bridge, albeit multi-handed, was, as we know, rapidly contained by the Metropolitan Police. So that's the first elevation. The second elevation of the threat level after Parsons Green was for the same reason as in Manchester, namely police manhunt for the perpetrator of the Parsons Green attack. Well, the short-term elevation of the UK national threat level from severe to critical is not, of course, the same thing as declaring a state of emergency, which would almost certainly require a derogation from Article 15 of the European Convention of Human Rights. You'll probably know it. Article 15 now reads, "In time of war or other public emergency threatening the life of the nation, any high contracting party may take measures derogating from its obligations under this convention to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with its other obligations under international law." Well, during 2016, although not here, we have seen such a derogation elsewhere in Europe, haven't we? Namely in France, after the attacks in Paris in November 2015, which included the Bataclan Theatre. That state of emergency remained in force without interruption for almost exactly 2 years. In fact, until the 31st of October just passed, when it expired and was not renewed. However, we should note that although the state of emergency in France has lifted, the National Parliament has sought to enact many of the emergency provisions, therefore normalising what were introduced as emergency measures. That is the subject matter for an entire lecture on its own, I'm sure we can agree. So, what is the new threat in the world as we find it in 2017? Well, both in this country and in parts of mainland Europe in particular, we've been seeing a move away from the use of the improvised explosive device, the IEDs, and the slightly more sophisticated attacks of the past decade, and to the emergence of lone actors deploying low-cost, low-sophistication attacks, often after they have been exposed to online propaganda and/or have been radicalised online. And this has been accompanied by, some would say even enabled by, the rapid and recent expansion in online communications platforms which are now used by terrorists. Not so many years ago, those planning terrorist attacks were still using text messages or Blackberries. They were meeting in person, in each other's homes, in local open spaces, and indeed during shopping trips for the everyday items that they needed to make the IEDs that they planned to deploy. And equally important, there would usually be clear influence exerted over would-be terrorists by radicalisers or trainers, those who spent time with their acolytes, inspiring them to take life and even to end their own life in so doing. So that is the shift. It's a significant threat indeed. But as the statistics for 2016 show, almost all of these attacks, in the UK at least, continued to be successfully detected and disrupted by the police and security services. When the evidence then comes to court, we've seen many examples of young men, mostly, they are young men, not all, but mostly young men, who have moved from a basic understanding and adherence to their religion to an extreme, radical understanding of what are said to be religious tenets justifying murder. What they claim to do, however, in the name of religion, is actually born from an absence of real understanding about the nature of the religion that they claim to follow. Well, the point is that radicalisers just a few years ago would suborn these young men often rootless young men prone to casual criminality, and brainwash them into a plan for action. That still goes on, but we're now seeing something comparatively new running alongside it, the online propaganda phenomenon. Well, whilst we must all wait for the full facts of the 2017 attacks in London and Manchester to emerge, it seems that some of those who committed terrorist murders on our streets may have reached their murderous state having been influenced by what they read and what they see online, just as much as by whom they meet. And it is this element of remote radicalisation which is actually difficult to spot. And where these awful crimes are facilitated by the use of social media, we want, don't we, to close down the criminal's ability to communicate. And yet, we must recognise that policing the internet and controlling social media comes at a very high price if it interferes with the freedom of communication which every citizen enjoys, and which is also, of course, enshrined in Article 10 of the European Convention. So to go further, we would risk unenforceable infringements on ECHR rights, and or we would push the current abundance of evidence proving terrorist activity online to go offline or underground into impenetrable places within the dark web from which clear evidence rarely emerges, and where the placement of a robust counter-narrative to terrorism is hard to effect and even harder to gauge. This is uncertain territory. Driving material, however offensive, from open availability into underground spaces online would be counterproductive if would-be terrorists could still access it. And once this material goes underground, harder for law enforcement to detect and much harder for good people to argue against it, to show how wrong the radical propaganda really is. So, to the question, can we legislate to rid ourselves of online terrorism? Well, my answer is that Parliament has already done so in meaningful ways, which include such offences as the dissemination offence, dissemination of terrorist publications, Section 2, 2006 Terrorism Act. I'm going to go no further for the purposes of this evening because we await the outcome of the government's counter-terrorism strategy review ongoing this year, and which has, I'm sure, been looking to see whether any amendments might hone existing offences given recent technological advances. And I'm confident also that the review is considering whether sentencing provisions in 2017 are apt for our world today. For example, where Parliament drew a line in 2000, and where 17 years is actually a long time in tech terms and in world terms. Finally, on this topic for now, it's important to consider, very important to consider, the interface between general criminality and terrorism. There's much useful research on this topic. I'm trying to read and absorb it. I recommend it. I'll give just one citation for those interested tonight, and that is by Basra, Newman and Brunner, 2016. It's called Criminal Pasts, Terrorist Futures, European Jihadists and the New Crime Terror Nexus. It's available online. And there's also a Europol, actually one more reference, there's a Europol publication called European Union Serious and Organised Crime Threat Assessment for this year. That also speaks in that space and is valuable. Next topic though for now, the threat from Northern Ireland related terrorism. The Security Service, MI5, has assessed the threat level in Northern Ireland from Northern Ireland related terrorism to be severe, so meaning that a terrorist attack is highly likely. And in May 2016, the threat level in the UK for terrorism related to Northern Ireland was raised from moderate to substantial, which means an attack is a strong possibility. The PSNI, Police Service Northern Ireland, has recorded, quote, compared to the preceding 10 years, between 1996-7 and 2005-6, the level of security-related incidents in Northern Ireland has been lower and remained relatively consistent during the past decade. During 2015-16, which are the most recent statistics available to date this evening, the number of shooting incidents that occurred was the lowest since records began in 1969. And that's reflected in the number of casualties from paramilitary-style shootings, which were at their lowest level since 2007-8. However, a significant threat still remains, as evidenced by the increased number of security-related deaths and paramilitary-style assaults over the past 2 years, and the continued number of bombing incidents. The attack, end quote, the attack methodologies and capabilities used by DR groups, dissident Republican groups, in Northern Ireland in 2016 included firearms, small IEDs such as pipe bombs, but they've also employed larger, potentially more destructive devices such as vehicle-borne IEDs and EFPs, which stands for explosively formed projectiles. And all groups, it is assessed, retain access to a range of firearms and explosives, and there is an ever-present threat of under-vehicle IED attacks. Just a little more on that. Between the 1st of January 2015 and the 31st of December 2016, the PSNI recorded 6 security-related deaths, all of whom were civilians. A security-related death is one which is considered at the time of the incident to be attributed directly to terrorism. There were also 49 shooting incidents and 27 bombing incidents. That includes, just to give you the definitional terms, where a bombing device explodes or is diffused. There were actually no incendiary incidents, slightly different technical definition, even trouble with that. There were 64 casualties as a result of paramilitary-style assaults, mostly loyalist, and 20 casualties resulting from paramilitary-style shootings, which are almost all Republican. So that's the picture, actually, very close to us in Northern Ireland. Back to the threat from other terrorism, which we must always bear in mind. The undoubted increase in the activity of right-wing extremist groups in the UK is reflected in the rise in the number of arrests this year relating to members of such groups. May I tell you that I am notified whenever a terrorism-related arrest is made, because I review the legislation which deals with pre-charge custody, and the upward trend will be seen, I predict, when the statistics for arrests during the last quarter of this year are released. In 2016, this right-wing threat, extreme right-wing threat, was brought to focus, of course, following the murder of Joe Cox. During the course of the murder, Mayor was heard by a number of witnesses to say repeatedly, "Britain first, keep Britain independent, Britain will always come first." Charged with murder, of course, sentenced to life imprisonment. The murder undoubtedly fell within the definition of terrorism, the Section 1 2000 Terrorism Act definition. And in December 2016, I touched on it earlier, the UK proscribed the group National Action, the most active, perhaps, and well-organised extreme right-wing group in this country. It's actually the first right-wing group to be proscribed in the UK since wartime. I was rather surprised to discover, I believe that's right. The British Union of Fascists being the previous proscribed group under previous legislation, of course, on the 10th of July 1940 under defence regulations. Well, the explanatory memorandum to the proscription for national action is a racist, neo-Nazi group established in 2013 and the allegations against it are based on promoting or encouraging terrorism rather than direct involvement in violence. I say rather than because the statutory test that the Home Secretary applies is Section 3 of the 2000 Act, as subsequently amended under the 2006 Act. The Home Secretary is empowered to prescribe organisations that she believes to be, quote, concerned in terrorism. And an organisation is concerned in terrorism or concerned with terrorism if it A, commits or participates in acts of terrorism, or B, prepares for terrorism, or C, promotes or encourages terrorism, or D, is otherwise concerned in terrorism. We should all be alarmed, I suggest, by statistics collected by the Home Office which show a number of sharp increases or spikes in racially or religiously aggravated offences. And they occurred in June 2016, after the referendum result, the Brexit vote, March 2017, after the Westminster Bridge attack, May, after the Manchester Arena attack, and June, after London Bridge Borough Market attack. What is troubling, or most troubling about this, is that the rise in such crimes does not seem to be returning to the same baseline after each spike. And in August this year, the number of racially or religiously aggravated offences recorded by the police was just under 5,000, as compared to just over 3,000 in January 2016. Not very long chronologically between the two, but you see the rise. So I've attempted to describe the current landscape from multiple perspectives. Where does all of this leave our terrorism legislation? Let me just turn to that. Perhaps we should ask ourselves the question, well, looking at our current legislation, how has it come about? Because history shows that terrorism legislation in the UK to date has been generated in reaction to major events and therefore often in haste. Let's go back, all the way back, to the Explosive Substances Act of 1883, because it's a good example. Passed by a late Victorian Parliament in record time and in relation to a mainland bombing campaign which lasted from 1881 to 1885. Still on the statute book now, of course. The Terrorism Act 2006 passed again in quick time, but with steerage from by Charles Clarke's Home Office. Another good example, which we all remember, following the 7/7 atrocity the previous year. And indeed, the Prevention of Terrorism Acts, late during the last century, 20th century, provide, don't they, continuous examples of emergency legislation intended to be enforced only for 1 year at a time, but circumstances required annual renewal for a long period during the Irish Republican era prior to the 1998 Good Friday Agreement. So it will, against that background, I hope, come as no surprise when I say that we should resist the urge to legislate in haste now, merely deploying the maxim that something must be done. And my central and repeated theme this year has been that Parliament has already covered terrorism legislation and has done so extensively this century. So we do not need to create gaps where there are none. Some amendment to existing offences in order to cater for the modus operandi of terrorists most recently, that is well and good. But the wholesale creation of new offences strikes me as unnecessary. And I await the outcome of the government review with interest to see what policy decisions are taken, which I shall then be happy to review as my role permits. That leaves the question of whether there are areas or specific matters within existing legislation where I can and do make recommendations. Again, it will not come as a surprise when I say that I have made some recommendations in my annual report for 2016, which I told you sits with the Home Office for fact-checking at the moment. I want to add, having said that the 2016 report, when you see it, I hope in the next month, is, in my view, nothing more than a modest start for a new reviewer. I hope that it deals with the important themes of the day in connection with our terrorism legislation, but it does not recommend a root and branch revision. Whether that is a disappointment for some will have to await the publication of the report. But I hope it will be borne in mind that the year under review in that report, 2016, was not one which presented the challenges of this year, some of which I've been addressing this evening, and therefore there will be more to come from me when my 2017 report is written. This has been the difficult year. Having said all of that, may I set out perhaps 4 areas in which I think that review and possibly change is needed. I'm going to conclude with these 4 areas this evening. I've selected these areas for this evening. They don't represent an exhaustive list, nor do they precisely foreshadow the 2016 report, which I keep mentioning. So having managed your expectations appropriately, I hope, let me introduce the 4 areas which I've selected. First, port and border controls. I've written and spoken about the exercise of the Schedule 7 powers under the Terrorism Act 2000. Again, there is a lecture here on its own. I find that there is a disconnection between the meaning and the intention of the legislation and its perception in the minds of many within our society. And to understand what I mean more fully, may I recommend the Building Bridges report published by Forward Thinking in July this year, which recounts my own community engagement visits in Bradford, Leicester, Manchester and London. It's on the Independent Reviewer website if you want to find it, or on Forward Thinking's website. Partly to cure this disconnection, as I've called it, and partly because it seems to me important, bearing in mind the principles of legal certainty, as well as ordinary transparency, I ask whether it would really be too difficult to achieve the adoption of a universal threshold for the exercise of Schedule 7 powers. And my predecessor, David, recommended a reasonable grounds for suspicion threshold, and lawyers know the meaning of that. The government has resisted it. I could press for the same. Is there a meaningful alternative? Well, I wonder. Bear in mind that Schedule 7 powers are already to be applied only in accordance with the criteria within the Code of Practice. And bear in mind too that the Code was amended in light of the case of Begal, which many of you will know about. So therefore, how about this? At the very least, a threshold test of reasonable grounds to support an officer's decision to exercise Schedule 7 powers in compliance with the Code of Practice. Adoption of such a test would be a step in the right direction, demonstrating the absence of either ethnicity alone or the exercise of these powers in a random fashion. For the highly qualified lawyers in the room, I recognise that this proposal carries consequences stemming from the fact that the Code of Practice is issued without parliamentary scrutiny. It's not legislative in that sense. It appears by reference to Schedule 14 of the Terrorism Act 2000, so it just has to be laid before Parliament. Now, the current legal impacts of the Code, they are set out under paragraph 6. I'll just read that out to you. Paragraph 6.2, the failure of an officer to observe a provision of a code shall not of itself make him liable to criminal or civil proceedings. And subparagraph 3, a code under A shall be admissible in evidence in criminal and civil proceedings. B should be taken into account by a court or tribunal in any case in which it appears to the court or tribunal to be relevant. So it's in play, and I'm questioning whether it should be brought into play in a much more formulaic way and requiring parliamentary scrutiny. So that's point one. Point two, arrest and detention. It's not always clear what exactly counts as a terrorist-related arrest. I've mentioned some of the definitional terms when deciphering the statistics which I've used this evening, but we all recognise that terrorism-related activity is not and need not lead to an arrest under the terrorism legislation alone. Simple proof of that fact, killers like Mayor in relation to Joe Cox MP and Adebayo in relation to Lee Rigby, rightly convicted under our general crime statutes, or in their cases actually under common law, murder. But both murders were firmly terrorism related, of that there is no doubt. But hence the definitional issue. It seems to me that more clarity is important in this area. And it follows, I think, that further work is needed to analyse and to understand the use of the distinct arrest and detention powers within TACT, the Terrorism Act, and PACE, Police and Criminal Evidence Act, respectively, because the consequences are different, as you know. These matters would engage many, of course, who work in this area, and that would include in particular the National Counter-Terrorism Police Operations Centre, who make some of the important decisions currently about categorisation of offending activity. So I put that in front of you. 2 to go. Third then, the consequences of pre-charge custody. So 3 follows from 2. Given the special nature of the solitary confinement in Terrorism Act custody suites for up to 14 days, when a warrant of further detention has been authorised by a judge following application at the end of the initial 48 hours, there is a premium on many key features of this regime, which is unique in our legislation concerning the pre-charge space. And therefore constant effort is required to make sure that our systems maintain the necessary standards. Allow me to list a few of the imperatives and then to reveal where they come from, because I'm quoting just 4. There must be universal and early reminder of rights once detained. No more of what are called protection vacuums whilst detainees are in a holding room. 2, there must be complete recording of the fact of a person's detention. 3, there must be respect for lawyer-client confidentiality, also known as legal professional privilege, which is fundamental to the confidence any detainee should have in the custody system and confidence in the criminal justice system in general. And fourthly, access to natural light provision for exercise. Simply said, but must be achieved. I'm not suggesting that the current regime fails, but I take those 4 aspects from the report to the Government of the United Kingdom on the visit to the United Kingdom carried out by the European Committee for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment, CPT Committee, published in Strasbourg on the 19th of April this year. And the markers they laid down, I suggest, are very important. Fourthly then, and finally for this evening, the need for reflection on existing terrorism offences, quite separate from what I've already said about any need for more law. What about what we already have? I've written elsewhere about the actual use of our existing terrorism offences, working of course from my own background as prosecution counsel during 15 years or more working in this area. And when I look back, I see some offences which are yielding more criminal prosecutions than I believe Parliament could have envisaged when enacting these offences. But I also see certain offences which are now used very rarely. Again, something which Parliament may not have envisaged 11 or 17 years ago when passing into law the Terrorism Act 2006 and 2000, respectively. Well, where does it lead? Well, at least consideration, I suggest, of the existence of any future need for the following offences. And I'll just mention 4 for your consideration, which are all hardly now used. Section 56 of the 2000 Act, directing terrorist organisations. You'll struggle to find many recent prosecutions for that. Section 57 of the same Act, possession of terrorist information or articles for a terrorist purpose, actually used now vanishingly rarely. Section 59 of the same Act, inciting terrorism overseas, very rarely used. Maybe reasons why: jurisdictional breach of some of our other offences, for example, the preparation for terrorism offence under Section 5 of the 2006 Act, originally had a jurisdictional limit here, extended in 2015 to carry across to conduct abroad. But the consequence is that Section 59, very, very rarely used. And then just one, it's actually three, but in the 2006 Terrorism Act, Sections 6 to 8, training for terrorism, very, very rarely used. Again, as with the previous statutory test for Schedule 7, these matters call for careful further exploration. I immediately recognise that, and in these cases include the fact that some of these offences are actually based on the ratification by the UK of international treaties. And Section 59 of the 2000 Act is one such example, and I think the training offences, Section 6 to 8 of 2006, are another example. But we should have this conversation, should we not? So that's the fourth and final. My thematic suggestions for this evening, I may or may not have whetted your appetite. I suspect, whichever way, that I've exhausted your patience. Dinner is already calling to you, as it is to me. So thank you. I will take questions if there's time, but thank you for this invitation to share my thoughts in these wonderful surroundings and in this university, which claimed me when I came up 34 years ago, which I'm proud to belong to.